traffic.
Yeah. I'm starting the recording for this meeting of the Delinquency Performance Standards Work Group slightly late. Matt and I discussed a little bit about some corrections to the draft JPAR standards, where Matt pointed out some terminology that needed to be updated.
Yeah, I think we also discussed just some of the differences between post-conviction relief and JPAR generally.
Yeah.
Which we've done in the past. Yeah.
Yeah, thank you. So we talked about how we took, or I took some of the stuff from the state bar post-conviction standards and kind of put them in these draft JPAR standards, leaving out the stuff that was clearly only applicable in the civil process that goes with post-conviction, and trying to retain the most salient parts of the text, with amendment for the right terminology. With that, do Matt or Deanna think that there's stuff that isn't in here that either should have come over from the post-conviction standards, or that just you can think of that that ought to be here?
I'll try to find the current.
The post-conviction ones, yeah, I should.
Well, no, I have the post-conviction standards open. I'm looking for the document that you're working on right now.
Oh,
I mean, you're sharing it on the screen, but I would need to scroll down to see what else is in there.
Oh yeah, okay. Well, first of all, I can make it smaller. But then I'll also put a link in the chat.
Thank you.
Link. That's the link to the Dropbox for the current draft, and the JPAR standards are on page. It's paginated page 30, but it's actual page 39.
And I have to apologize for driving right this second, and my
no problem.
Went a little long. I'm sorry.
No problem. I appreciate you jumping on. We're a small group today, but hopefully we can get through the JPAR conversation and then anything else that's outstanding.
I see. So part 2 is what we have. Whether the youth is mentally fit, blah blah blah. I know you've made some of those. Okay. Well, so if you're looking at the I guess sort of like some of the other parts of the standards, I don't how overkill do we want to be in including like every possible detail in these when they're already kind of encompassed by like the other basics that are included in the juvenile standards. Like prompt contact with your client, getting the record, the transcripts, the previous counsel's file. I mean, all that stuff that you like. Do we need to include those? I guess is my question. Because this could be a very long section or it could be a short section. I guess if you're familiarizing yourself with the post-conviction relief standards, then you probably don't need to include it all in here. But I'm open to whatever the agency, I guess, wants to do as far as thoroughness here.
Yeah, I mean, I think I'm interested in both of your thoughts. That was exactly what I was struggling with, and it would be quite the current Oregon State Bar post-conviction standards are 18 pages long, and the the current draft delinquency performance standards for us are 45 pages long at the moment. So it'd be a pretty big,
Yeah.
it'd be a pretty big addition. And so I think I tried to address that, as you pointed out, Matt, with the first black letter, which is you should know and meet the post-conviction standards from the state bar. But that does feel a little disingenuous to just kind of incorporate by reference. And then it's also weird to pull some but not all of the language from that into the best practices. But I did think some of the best practices were worth calling out, like just, even in part because, as you, I think, pointed out earlier, it's weird. A weird thing about JPAR is that it is happening in the same court, and in some ways part of the same procedure as a delinquency proceeding, and yet it is so different. And so that's part of why I wanted to pull out the best practices. The first best practice, or number one, that is, understand that this is a collateral attack, that it's a different process, it's not an appeal. You need to go create a whole new, it is not record based. And so that seemed worth pulling out and highlighting. But I think your point is well taken, Matt. There's a whole bunch of stuff in the post-conviction standards that we could also decide are important enough that they should also be called out individually, or we could decide, well, we're incorporating by reference the state bar standards, so we don't need any of this. I don't know.
Yeah, so I guess on the one hand, the qualification standards, that's not listed here, but at least in the juvenile qualification standards, you are required to be qualified for the offense for which you are conducting the post adjudication relief
Right.
representation.
Mm-hmm.
The way I read this, it doesn't really talk about that, but I suspect that's similar for adult cases. And just to, Dan, in case I'm staring at the adult PCR bar standards,
Okay.
Which has a lot of reference to civil, rules of civil procedure and the like, which don't apply because JPAR all flows from the juvenile code. And as Tom points out, is actually you file it in the same case. You don't file a new civil case.
Right.
Asserting the claims. So, like a lot of that stuff is not necessary, obviously. The one thing I did like that's in here that probably ought to be included is that, and I'm going to struggle to find it now. Where's it taken? Counsel. There is a section that says counsel should not be the trial counsel should not also be the counsel that provides post that gets appointed to post conviction relief. I think that's clear. We talked about that last time, but I think throwing that in there somewhere is probably important. As a black letter, like do not do this type of situation.
There it is. I think it's number 6 under 6.2 in the adult standards. Should not have represented the petitioner during the underlying case.
Yeah. Will not ordinarily be. And I think we had talked about that last time. There are scenarios where you could learn new information or be in a position where it wouldn't be a conflict to do a JPAR petition for your former client, but most of the time you wouldn't want to put yourself in that position.
Yeah. So do you think if we adopt that that subsection for JPAR, would you think it would go in the black letter or in the best practices?
Do you mean the part about, sorry, the part about not having been trial counsel, that thing?
Yeah, yeah.
I think that needs to go in the standard.
Yeah. I agree. I think that's important enough that should be in there. And this whole 6.2 section is pretty, well, don't love all of the language. Because it's not totally.
I think a bunch of that stuff is stuff. So like 6.24, I think became best practice 2.
Yeah.
And 6.23 became, or is referenced, I think, became 1 C.
Mhm. So yeah, I think we're good on that. I would definitely include the section about not being trial counsel.
Okay.
Yeah.
I agree with you on that.
Great. Yeah, I'll go back and make that part of the standard itself.
I'm just I guess just scrolling through here.
Yeah.
I don't know that we need do we need additional standards on like contacting your client, keeping your client, updated on status of the case, sort of the basic. There's just a lot of the stuff is the basics of representing clients, period. It probably doesn't need to be duplicated here.
Right. I guess I would tend to agree in the sense that we've already said that needs to happen in a case, in
Yeah.
a delinquency case in the
Right.
corresponding section earlier, and we're not saying because this isn't a different case, it should still apply.
Yeah. And if you need to be
Agreed.
qualified to handle the case at the trial court level, then you already are aware of what your obligations are to representing a client.
Yeah.
In a post adjudication situation. So I agree that would be unnecessary, duplicative. Capacity, like obviously you need to know if your client can aid and assist. Independent investigation. People should be qualified. You can get funds. And I guess this is sort of the section where maybe we get to, what do you need to obtain to adequately represent someone in one of these?
Mm.
And it's like, the FTR, which is the audio record. If you want to have those transcribed, great. Prior counsel's file. If you have reason to investigate, external sources, that want clients' records, depending on what the claim is. It's sort of laid out in the standard 6.4 of the PCR and under implementation. Those are sort of like the basics. If you aren't doing those things, then you're probably not doing best practices, right?
Mm-hmm.
So,
yeah, I mean, I guess that kind of gets to the question of to what extent are we incorporating by reference the PCR stuff versus do we want, is that, I guess, are you saying, Matt, that those particular things are important enough that you would like them reiterated in addition to saying someone should meet the PCR standards? Or is it just like, it feels weird not to have them there? Or should we reconsider whether or not this reference is even a way to do it.
That's a good question. I guess who
Yeah.
can I ask a dumb question? Like who I know we're writing this for everyone to look at and to reference on what they're supposed to be doing.
Mm-hmm.
But are we writing this for someone who's never had one of these cases before? Or are we writing it for like as a reminder or both?
Yeah, I mean, I guess it would be. It is both a floor in terms of the the black letter and the aspirational. So I think a person who'd never done one before would need to know, like, okay, at minimum I have to do these things, but I think it's also a document that's a reminder for even experienced practitioners of what ought to be done in cases. It's also a tool for the agency. If someone gets a if, if we're alerted that someone might need to improve their practice, then we can cross-reference what they're doing versus the standards and say, well, here, this is something that an area where you're falling short.
Mhm. I mean, I guess to the extent that PCR and JFAR are kind of, kind of sort of the same kind of relief and involves some of the same kind of practice, but that when you're representing youth, there are different need to keep in mind.
You're breaking up just a bit.
Oh, I'm sorry.
Yeah, we didn't hear the last thing you said.
Is this better?
Yeah.
Oh, okay. I said I thought that there was maybe an answer in there somewhere, but I'm not sure that there is. Others, I mean, I guess I don't have an answer.
I guess a concern I had was if we don't include a cross-reference to the post-conviction standards, then I kind of feel like we have to include all the post-conviction standards except the ones that we explicitly decide are not applicable, like the civil procedure stuff. And that seems like a lot to include. But if our feeling is, well, a cross-reference is not that helpful, then maybe the answer is I go back and I redo it and I try to add in all that stuff. But I don't know. I mean, maybe the cross-reference, maybe what part of what you were saying, Deanna, is that it really is very similar, and a person practicing one should really know how to do most of the other. And it's just that there's some differences on the margin, and I highlight the differences. But maybe that's wrong.
I think that's exactly what I was trying to say, actually. Yeah.
Okay.
In looking at this, I think we should reference the PCR standards for sure. And I think there's just a couple lines here on the implementation that we could include that would probably make me feel good that we've got enough in there on its own that that we've covered it. Because a lot of the stuff at the back end of this is again stuff we already have, which is like the last section is duties of appellate counsel. The second to last is obligations of counsel after trial. That's just post adjudication representation. We've already included that. The litigating claims, again, is a lot of civil procedure, local practice, filing requirements. Again, we don't need to include that. Um, asserting legal claims. I think that part is the sort of self-explanatory part of what we're doing here. Like, you're looking for constitutional violations or other irregularities in the proceedings. I think that is explained by the statute that grants the authority for this in the first place. So I think it's really just like this standard 6.4 independent investigation is really the section we didn't bring anything over really
Yeah.
yet.
Yep.
And I think we can shave off a lot of the extra language here that is not totally applicable to, and include just a few things that I think need to be black letter. And then I think the cross reference at that point probably is fine.
Okay.
And so what I'm looking at is you're looking at the bar standard 6.4. So implementation 1. It's not even this whole section. It's actually just the first 2 sentences. Because the second half of that is about pro se claims. And so it's just counsel should conduct a thorough and independent investigation of validity of the underlying adjudication, disposition, when applicable, appellate proceedings, should examine the entire uh, delinquency case for evidence of substantial denial of state or federal constitutional rights. I think we can drag that over with the modifications to the language.
Yeah.
And then actually think we can probably skip this whole section on like that investigators and witnesses need to be qualified. And, we already have, I think somewhere in there that we can get funding for experts and whoever we need from, it says OPDS there, OPDC.
Yeah.
I think that's overkill to include that again. If you're qualified to do the offense that you're reviewing, most of the time it's going to be a serious offense and you're going to have a lot of experience getting, experts and whatnot from OPDC. So then you get to 3, and this is the part that I kind of felt like was important. And again, the second half of this is about sharing with the petitioner, which we can leave out, which is, investigation shall include a thorough review of all transcripts of the proceedings of the delinquency case, obtain review transcriptions if necessary, and then go to 4, should obtain a review relevant records documents, including the trial counsel's file, all that whole section. And then I get 5, I guess. I don't know. I should ordinarily interview trial where applicable appellate counsel in a criminal case. That's interesting. That's in there in the post-conviction standards. I mean, I've not personally handled a post-conviction relief, like represented anyone on that. I, having practiced adult criminal defense in this state for over 20 years, have been on the other end of post-conviction relief claims. And I don't know that I've ever been interviewed by the PCR council, but anyway, or even really been invited to. That's interesting. I don't know that we need to include that. It's just like if you're getting the file and that's kind of, you might ask some questions, you might not get any answers. It's a juvenile proceeding, so I would hope prior counsel would be friendly on that front, but I could go either way. You might just put, I don't know that part needs to be a black letter, but I think it's important to include that you need to get all the other things that are listed.
Yeah.
In order to adequately represent your client on the case.
Yeah. I'd done some
I've never
interviewing.
done PCR, but I've been PCR.
Yeah.
That's for sure. And um, yeah, I am infrequently interviewed, but I have been interviewed. The thing that, so a problem that I see is that, like frequently trial counsel takes post conviction claims as like personally insulting or something that just mystifies me. Um, I'm wondering if we should, like in the best practices, maybe add a clause that says, trial counsel should cooperate in providing materials, and that gives um, and then that gives JPAR counsel something to point to
Besides your regular ethical obligations.
besides your regular ethical obligations. I mean, yeah, that always just mystified me. Like, what, you're
Well,
trying to like get my client acquitted, which was the thing I tried to do in the first place. So yeah, I'll help you.
I mean, I think people like to not feel like they're
Mhm.
being blamed for the the conviction or whatever. I understand
Yeah.
the psychology behind like the not loving the the process.
Yeah, I did a couple interviews when I practiced post conviction in Louisiana, where uh, the lawyer I was trying to interview then like stopped midway and said, "I think I need to consult counsel," even though it was, as you were saying, Deanna, like theoretically we're on the same team. I'm not
Yeah.
I'm not like bar counsel here coming after their card, but
Right.
it was taken that way. It was taken like this is going to result in me losing my license in some way. And I was like, no, ineffective assistance is totally separate from
Right.
bar license generally, unless you're came
Yeah, I mean,
very, very far short.
I agree with you, Deanna. If I screwed up and they deserve a new trial, like they should get a new trial.
Yeah, totally.
I don't beef with that. When
Show me the sword, I'll fall on it.
when the PCR alleges a bunch of illegal and false things that I allegedly did, then I maybe have a different problem.
Maybe, yeah.
I like the idea of encouraging trial counsel to cooperate. I mean, it
Yeah.
doesn't seem like there's any harm in that.
Yeah, I think I have no problem putting that in there. I mean, ethically, you have to. So it's your client's file. It's not yours.
Right, yeah.
Um, I'm reading the state bar standards that seem related to this, where it says post-conviction counsel should be prepared to exercise skill and tact in relations with prior counsel.
I saw that. I didn't think we needed to include that in.
Yeah.
I mean, there's a whole section in here in communicating with your client about, being careful, taking great care and building trust because, these are adult clients that have typically been in DOC for like a decade, at this point. And yeah, it might be a little grouchy and might not trust you, had some prior unpleasant experiences with the criminal justice system. And I get all that. Like, I don't think any of that needs to be included in the JPAR section.
Yeah, I think would be repetitive. Well, I can go after the meeting and take all these suggestions and kind of flesh out the current draft to add these in. I think some in the black letter and some in the best practices, but I think that it sounds like that feels like that would get the bulk of what we want essentially to reiterate and kind of highlight for JPAR practitioners to make sure make sure none of that is missed. But we still covered what needs to be covered.
Okay.
Great. Well, I know. I think asking about that was the main thing I wanted to ask about, but I also think that there's probably a lot of there's a huge swaths of this current draft that we never discussed as a whole group because of the timelines we're on. So I don't know if either of you have looked at any part and want to discuss them, or if you want me to pick out parts, or neither.
I just was focusing on the JPAR stuff because of our discussion last time, so I haven't really looked back yet. Besides what we've gone through together, Deanna.
Yeah, I honestly, until last Wednesday, I was preparing for a waiver hearing, and so I'm now just sort of coming back to, oh right, I have this other thing I need to do. So
Oh, they withdrew the waiver hearing, right?
they did. They withdrew. Yeah, they withdrew their motion for waiver. Tiffany Harris, and I think she's right, thinks that what happened was the DOJ called them and sort of basically was like, stop doing this to us.
Wow.
Because they were going to go forward when their expert agrees with ours that our client isn't waivable. So the beauty of Washington County.
Well, congratulations.
Oh, thank you. I wish I could say I had done something magical, but other than, I guess, just continuing to insist that we were going to have a trial and that our client wasn't going to like agree to be waived into adult court. that was really the only thing we did.
Nice. Well, we could talk about the experts section that is on the screen. I believe that was brought up in the criminal performance standard work group and didn't exist in any way in the state bar standards. And so the criminal work group came up with this language, which then I pulled over so that they are parallel. And that the criminal standards are currently, out for provider feedback, and so could still be updated based on that feedback or commission feedback. But if y'all have any thoughts on this draft language, that'd be great as well.
Yeah, take a look at it.
Yeah.
So, I mean, I think that language is fine, other than, there's a couple spots that need to be converted to
Oh, yep. I see that.
Juvenile lingo. Earlier in the document, we talk about, okay, there it is, 2.2. There's all the different gathering information about the youth, so on and so forth. I mean, I don't think we need to connect the dots as to like what kind of experts you might want. Seems like a unnecessary branch. But that's the only thing I was thinking about.
Um,
Seems like people should be able to put 2 and 2 together on that.
yeah.
Mm-hmm. Yeah.
Was it just this one where I'd still said criminal that needed to become delinquency, or was there more than one?
Let's see, 3.2. Criminal cases. I guess they are still a prosecution, aren't they?
Mm-hmm.
No, I think that's it.
Okay. Yeah, I tried to go through and change client to youth throughout, and then a lot of this was from the OSB, and then so it was, and the OSB had the merged criminal and delinquency. So I think I tried to catch all of that, but I'm going to do a couple more passes. I'm sure I missed other places throughout this document, but I think most of that has been changed. But definitely let me know if you see any throughout. Otherwise, I think that the expert section and the JPAR section and the waiver section that we discussed at an earlier work group, I think are the main totally new sections, and everything else is a modified version of the state bar standards, either made either identical or made juvenile, or juvenile or delinquency specific. And then particularly the earliest sections that we all worked on together, I think are probably a little bit more robust. But I guess we did start from KO and Nora's document and they had made it pretty far through originally doing the updates. So I think it's pretty far along. I think I said this at an earlier work group, but I don't know if you both were on at that point, that the current schedule is that, assuming the commission is okay with it, the draft, I'm supposed to turn in a draft of these on August 31st. They will then go out, OPDC will send them out to the whole provider community for feedback, and then they will also go in front of the commission for kind of a first look during the same period when they're out for provider feedback. So this would be at the commission September meeting. And then there'll probably be 45 days of review period, so through October 15th for any feedback. And then we'll try to incorporate commission and provider feedback throughout September and October, and then take it back to the commission in November for adoption if things are on track.
Okay.
So I guess I know both of you haven't had a chance to look all the way through the document. I'm going to try to schedule one more meeting. I know August is tough for folks, especially with school starting at the end of the month and stuff like that. But I'm going to see who wants to jump on one more time to talk about anything. But also, if either of you look through the document and notice anything that you want to either specifically talk about with me or with a larger group, or you just want to email me and say, hey, this is a thing that I think needs to be updated, that'd be great. Because I'd say about 70% of the document has had good outside eyes on it, but there's a 30% that has been me muddling through. So it would be good to have backup on that.
Okay. When you're finished, I guess, doing whatever changes we did today, will you send another link for?
Yeah.
I don't see, the one I have isn't like auto updating on whatever you're doing. I don't know if it's supposed to be or not, but I'm also not
yeah,
computer
you're right.
man.
You're right. I am updating this.
Okay.
The screenshot I'm sharing, I'm updating a downloaded version because the online Word doesn't always play nice. So yeah, I will make
Okay.
those changes and I'll upload it with today's date, and then send out a new link.
Thank you very much.
Appreciate
That's very
that.
helpful to a Luddite like me. I appreciate that.
Well, I appreciate both of your feedback and time. If there's anything y'all want to talk about today, I'm not trying to end the meeting short, but I'm also happy to give you your time back, since it's just the three of us today.
Yeah. Well, I wouldn't be sad to go since I have a 2:30 hearing.
Okay.
There you go. All right.
Okay.
Well, good luck with
Good
the
to see you,
hearing.
Deanna.
Thanks. Good to see you too. Bye.
Thanks,
All right.
Colin.
All right. Thank you both.
Bye.